Welcome to LexDiscuss Cafe, where we explore the fascinating world of law and intellectual property with some of the brightest minds in the industry. Today, we are honored to have with us a true titan in the intellectual property law, Lakshmidevi Somanath. With over 2 decades of illustrious career, she has worn many hats. Faculty member, judge at Intellectual Property Appellate Board, and a renowned IP counsel and strategist. She continues to make significant contributions to the field. Get ready for an enlightening discussion with one of India's foremost IP experts. So, Lakshmi Devi ma'am, welcome to Let's Discuss Cafe. We know the amazing journey you have been doing. So, people who don't know anything about you, please give them a brief professional journey.
Yeah, thank you, Avinash. I'm a first-generation lawyer, and my legal journey started in 1997 when I enrolled in the law course. So I had the full support of my family, and once I passed out from the National Law School, Bangalore, I taught for a year in the National Law University, Jodhpur, following which I entered the profession. I joined as an associate in Surana & Surana in their intellectual property practice. And after 2 years, I commenced my independent practice. I was practicing intellectual property and constitutional law before the various high courts and tribunals. So post that in 2020, I was appointed to the Intellectual Property Appellate Board. I practiced before the Delhi High Court in IP matters. So the journey has been from an academician to a law firm associate to a practitioner to a judge and then back to practice. It's been colorful, and I'm indebted to various individuals who have guided me on in my journey. It's not one single person, but I have learnt from several of them. The most notable would be my professor in law school, my professors, and also Honorable retired Mr. Justice Manmohan Singh of the Intellectual Property Appellate Board. He was a chairman at that point of time, plus various other legal luminaries in the field who serve as my daily inspiration. So yes, that's been my journey so far.
Wow. The word you use, colorful, is quite apt for your journey. And who says lawyers' work can't be interesting? You have done everything, almost everything that is there to do. We'll go into detail of each and every aspect of your professional journey. But I wanted to start from the first phase. So, ma'am, you did your schooling in a state board. Then you graduated from law from University of Kerala. And then you pursued LLM from NLSIU Bangalore. So in the hindsight, how do you look at this experience, especially your experience at NLSIU Bangalore? What was your experience before going into the law school? What was your expectations? And what changed after you graduated?
So I joined law in 1997 and I graduated, yes, I completed my bachelor's degree in 2001 and my master's in 2003. In 2003, yes, all the other law schools were slowly coming up. We already had Nalsar, Hyderabad, NUJ's, Kolkata, and we had NLU Jodhpur that had completed 3 years by that time, 2 or 3 years. When I was a student, the National Law School Bangalore was the institution to go to for law. It was the primary institution. But now we have law universities in almost every state, which is really good because people, irrespective of where they come from, they have access to quality legal education. Whichever place they are based in, they always have the access to legal education. They do not have to really travel and go and study. So that's a change. And all the law schools are performing equally well is what I have seen, other than certain parameters here and there, which is always the case when you compare 20 to 30 institutions, but all of them are equally good. I see when students come to us for internship, I do not find any of them in any way less than the other. All of them are equally bright, brilliant, talented, go-getters, and they have such a thirst for both the practical knowledge and also the desire to excel. So I think not just the National Law School Bangalore, all the law schools are doing a really fine job.
Wow. So you are saying that all the law students in your eyes are equal. It doesn't really matter what law college they are coming from.
It doesn't really matter.
Right.
Because,
Are you,
I mean,
are you absolutely sure? Because I believe it does matter whether you are from an NLSIU Bangalore or you are from 5-year college in some remote part of India. Do you really think it doesn't really matter the students from those two colleges?
now looking at me, could you analyze from my journey so far and where I am now and the way I'm speaking to you right now? Could you analyze where I have studied, the institutions, my background?
No, you are right. You are absolutely. You might have come from an LSIU Bangalore or you might have come from another college. That is absolutely true. But it's been a really long time since you graduated. It's been close to 20 years now. But just right out of law college, or even when someone has like a couple of years of experience, do you really believe there is no difference whatsoever?
There is no difference whatsoever. It depends on the individual. So
Right.
if there is a particular person with a very bright spark, maybe from college in an extremely rural belt where the college also does not offer much support in terms of providing mentorship for internships and probably also exposing them to the practical realities of the legal profession before they pass out, it does not matter. As long as the particular individual is focused and determined and dedicated, then they can excel. In that context, even coming to the question of language,
Right.
I have seen a lot of students who are not legal students, who are not fluent in English, but extremely bright and having a desire to excel in the legal profession. And for them, I do not think language would be a barrier in going forward also. But then obviously they are going to pick up on various legal skills and also the English language as they progress in their profession. That's going to happen naturally. But if the individual is determined, I really do not think that the background where the particular person studied is ever going to be a barrier in the practice of the legal profession.
Well, that's absolutely true. But I just wanted to understand if that's the case, in your experience, you have seen whether if somebody is hailing from a very prestigious university, he or she getting a little preference over someone who is not. Does that happen in your experience? Have you seen that around you?
In my experience, I have not been at the center of anything like that. But then, yes, I've heard of it that there are various law firms who cherry pick candidates from the top law schools. And once they are into the system, also preference is shown to them. I've heard of it. We also go for campus recruitments. We go to various campuses for campus recruitment. But then we do not differentiate between law schools. And once they are in, we do not differentiate between the people whom we have recruited based on their background, which institution they have come from. We do not do that.
Ma'am, even though I come from a non-national law school, I do it. To be honest, when I'm recruiting people, there is that subtle bias. And I believe in a way it is fair as well. See, imagine this. There's a guy who in his plus two has worked really hard and gotten into a good law college or national law college. And then the guy who hasn't done that. So the first guy who has worked hard, he should be getting some advantage out of it. It would be unfair to that person and saying like whatever work you have done at plus two level is meaningless now. And I didn't study hard in plus two and that's why I couldn't get into a national law school. Other people did. So they should be getting advantage. But as you rightly said, it shouldn't become a self-fulfilling prophecy just because we have a perception that, okay, national law school students are better. And in most of the cases they are. So they are only given the opportunities and then the rest of them are ignored. Because they were just given opportunities earlier, they were able to excel. It shouldn't work like that. So I'm happy and a refreshing change. And as I said, that there is a subtle preference given to national law school students. I do it. If I am hiring two people with exact same credentials, and one is from national law school, one is from non-national law school, I'll probably call the national law school guy first for interview. I'll be honest about it. I'll do that when I'm hiring people. Moving from that, the thing that I wanted to always understand is that when we look at the Indian legal practice, and compare it with the Western counterparts, we don't see as much specialization. So you have like three category of lawyers: litigators, corporate lawyers, IP. Taxation you have there, but I think more or less it has been cornered by the chartered accountants. My first question is why we are not so hyper specialized as our Western counterparts. Second, why is IP specialized? Why do you see only IP getting specialization and you don't see that level of specialization in any other area?
Okay. So I would say that that particular trend of not super specializing or hyper specializing would have maybe been there till the 2018, 19 and all that. But now there is a trend for super specialization in India also. Yes, you're right. The broad specializations as per the area of practice would be litigators who go to the courts every day, argue. Then we have the corporate counsels who support all the legal functions of a particular corporate. And we also have non-litigating lawyers within a law firm. So that would be the third category. And the fourth would be the legal academicians who teach the professors at various law colleges. Other than this, in the recent past, there have also been other aspects of the practice of legal profession that has come up, legal journalists. There has been a trend that has been going first starting from the print media and then the online media, also audio, visual media. So that has come in. Now going for subject matter specialization, yes, the broadest category would be the practice of civil law, criminal law. That was it 50 years back.
Yeah.
And then people got into specializing in writs, intellectual property, taxation, corporate law, all that. Now we see that there is a lot of super specialization within taxes, indirect taxation, within corporate law, specifically in transactionary, due diligence, M&As. Within intellectual property, we see people who are specifically focused on trademark litigation. That's it. Or IP valuations. We also see people who majorly deal in geographical indications or the IT Act and call themselves specialists in that. Over and above this, I find so many emerging areas. People who specialize in IP and fashion law, or people who are specialists in sports law and IP. So yes, the trend of hyper-specialization has reached India and it will further define itself in the years to come. It was not there and it is in vogue in various other countries. But in the years forward, that would be the space in India.
Right. We are seeing specialization in IP and then, hyper specialization in further niche parts of. But why aren't we seeing that culture in other parts of legal practice, for instance? Like, we have corporate lawyers. We rarely see corporate lawyers who are saying that we just deal with corporate fraud or we just deal with corporate insolvencies. Why is trend not coming there and why is it coming in IP industry? So one of the hypotheses that I have on this is that because IP is controlled by a centralized entity, which is like, if you look at most of the MNCs, there will be one company which will be holding all their intellectual property. And if you are getting work, you are mainly getting work from that US entity. As an IP attorney, you won't be dealing with their Indian subsidiary, which is handling. You would be directly dealing with the US or the European holding company, which is holding that IP. And because you are directly getting work from a US entity, you are seeing that culture of hyper specialization getting adopted a lot quicker. But because the normal corporate practice is not directly dealing with the US counsels, that's why they are not seeing. Is that hypothesis has any merit?
Yeah, so it may be that way. You're right. See, intellectual property, there is a particular body before which all filings and prosecution happen. There is something to streamline the practice. Similarly, we have the tax authorities. So that is one way in which new areas evolve. Just as you see in the US, they have the practice of going in for separate teams for ITC Section 337 litigation or pharmaceutical litigation, technology transactions and litigation, or life sciences litigation, trade secrets litigation. So we see separate teams in those firms which deal with each of this. I think, as you said, it depends on the need of the industry. So the moment there is a requirement, then the practice of the law evolves to suit that particular requirement. And of course, having a nodal body that controls certain functionalities like filings, prosecutions, and all within a particular area also contributes towards it and hastens the process by which a particular legal specialization gets coined. So yes, IP and taxation can all derive from that. Coming to newer areas like fashion law, sports law, and all that, there is no particular body exactly that governs, even though there are certain entities. That depends on the latest trends, since there is the enhanced focus on not just one sport, but various sports in the country as of now, the same as it is in other countries. So then the particular area of law has now evolved.
Absolutely makes sense. So now you have been an adjudicator as well as you have argued in a lot of landmark cases. So could you share us an intriguing story, behind the scenes story from any of the landmark cases that you have been part of? Obviously, having the caveat that now you can, reveal the info in the public forum.
No, I think I could just talk about
Yeah,
some of the cases
landmark
that
cases.
we
Yeah,
have.
please,
Yeah.
let's just do that.
Yes, for professional discussion and also for academic interest for any of the students who would view this. So one such case would be the case of the Mark Eveready, which was in question in a case called Eveready Industries versus Kamlesh Chadda. So this was a discussion on the use of the mark Eveready. Eveready Industries was using the mark Eveready for batteries since 1942. 1934 they were incorporated. 1942 they were using it. But the respondents also said that they had the mark Eveready and they had adopted it very honestly in 1985. The problem was that Eveready Industries had applied for their mark only in 1994. So acquiescence was discussed, honest adoption was discussed, and the question was whether everready was an invented word. It was absent from the English dictionary, but then was the coining of the word everready in any way descriptive of the goods that were offered, ever ready. Anyway, we went through all the documents and we also saw that the respondent had also registered other brands like Amul, Deluxe, HMT, Craftsman. So we understood that there was a malified intention and there was no consistent use of the mark also by them. And we were able to reach a decision. This particular decision was also later referred to and upheld by the Honorable High Court of Delhi, and Eveready was declared as a well-known mark. So this is one notable decision that I have. And there was also another case of Britannia Industries where the mark of Good Day was in question. The respondent had filed an application for good day in respect of salt. So good day, both words from the English dictionary. The question was whether the plaintiff could succeed in that matter. But again, the respondent did not have any explanation for adopting the good day word. And the usage that was proved by Britannia was extremely vast and prolific to record the entire history of the brand. It's one of their most popular brands. So in that particular case also, the board declared Good Day to be a well-known mark. And this was also relied upon by the Honorable High Court of Delhi in a later case that came up before them of Britannia Industries. In that, I think the opposite product was toothpaste, which contained Good Day. In that particular case, the declaration of Good Day as a well-known mark by us was referred to by the Honorable High Court of Delhi, and Britannia scored in that case also. These are two of the cases that I remember.
Thanks for sharing these stories, ma'am. Great insights there. As you mentioned that because a lot of students might be listening to this, so I wanted to ask about one of the interesting and one of the unique aspect of IP litigation is your ability to sue at plaintiff's principal office, which simplifies the proceedings a lot. So would you care to explain this provision for some of the law students who don't know about this?
Yes. So primarily the place to sue is that of the plaintiff or also where the cause of action has arisen. various cases that have come up recently, the honorable courts have widened the ambit to a very large extent. So as of now, if any point of contact can actually be shown to a substantial level such that the plaintiff is seriously aggrieved within the territory of that honorable court, then it can be considered for the court to seize jurisdiction of the matter. And as regards goods that are available online in e-commerce portals, if the particular e-commerce portal, the goods can be sourced within the jurisdiction of the particular high court, then yes, the court can seize jurisdiction of that matter. So even though it starts from the premise that place of the plaintiff, the ambit of jurisdiction has been widened to a very large extent by the courts in various decisions.
Wow. Thanks for sharing that, ma'am. Let's talk about the buzzword these days, which is ChatGPT and, the generative AI. So far, did you have any interaction with ChatGPT, and what was your initial experience?
So we do use ChatGPT in our daily work. What we normally do is we run drafts through ChatGPT for second eye or an analysis on what we have done, where it supplements to it in great measure. And we also, at certain points of time, generate the entire document as a mirror document from ChatGPT so that can be compared against the work that we have done to see where there is room for improvement by the team. Now, all this is fine, but then the prompt has to be given in exactly the coherent manner as can be analyzed by ChatGPT. Otherwise, then we face problems. So that's one challenge that we have come across. So ensuring the accuracy and reliability of the responses that are churned from it in such a complex field of practice still poses a significant challenge. Also, we never ever rely 100% on any particular document or any particular advice or any particular opinion that is provided by ChatGPT. Our reliance would probably be 15 to 20%. That's it. Because determining liability in cases where ChatGPT's advice leads to adverse outcomes will also be an issue that the courts will face in the days to come. And we do not have any AI regulations coined as of now in India, even though the committee has been set up by MeitY and they are on the job. Until that comes in, then we would have a framework in place, a legal and regulatory framework that governs the use of AI in law. And it would also include the data privacy law and professional conduct rules of the lawyers. But until that comes in, ChatGPT is to be engaged with caution, not more than what is required. So as of now, we use it for research and drafting assistance, document review and analysis, client support as is required, case outcome forecasting, what exactly it feels would be the broad outcome when certain parameters are referred to it. So this is what we use it for as of now.
That's interesting. So are you guys using just ChatGPT, or you are using some modified version of it, or version that has been modified especially for lawyers?
We are not using any version specially modified for lawyers. We're just using the plain version.
Plain version. Okay, makes sense. So now we have a surprise for you. Okay, I can't believe I'm playing rapid fire round with the next judge, but let's see. Yeah, will you enjoy it or not? So it's the rapid fire round time. You have to answer very quickly. Okay, ma'am, are you ready?
Yes.
Awesome. First question is, favorite IP related book or resource?
Okay, that would be Cornish.
Okay.
On intellectual property law.
Okay, very interesting. What gets your adrenaline pumping? Trademark litigation or patent litigation?
It would be trademark litigation.
The third question is, if you could have dinner with any historical figure related to intellectual property, who would it be?
Related to intellectual property, I mean, the person is right now amongst us or?
Doesn't matter.
Okay, I would probably have dinner with Nikola Tesla, a prolific inventor, the person who's really contributed to the field, even though his wild and bizarre ideas, that's the way his ideas were termed at the time, did not garner much public support at that point of time. and he often lost in the race to patent.
Absolutely. So you can probably give him legal advice because he has relinquished a lot of his patents. That's a great answer. So if there could be one word to describe your litigation strategy, what would it be?
It would be to predict and forecast what exactly the opposite party would bring out as their arguments, and to extinguish the fire at the outset when you present before the court your arguments.
Very interesting, ma'am. Coffee or tea?
Tea.
Okay. So this is very interesting question. Your favorite legal jargon that sounds impressive but is surprisingly simple.
It would be ignorantia facti excusat, ignorantia juris non excusat.
Yeah. Yeah, for people from non-legal background, it may sound really complex. For people who don't know, it means that ignorance of fact can be excused. Ignorance of law can't be excused.
Cannot be excused. That's right.
So that's pretty much it. Thanks a lot for playing the rapid fire round, ma'am. So as we're running out of time, I'll ask just one question. What would be your advice to young lawyers who want to specialize in intellectual property? And is there any lesser known aspects they should be focusing on?
One thing is, having just a law degree in the current scenario is not really the way you could enhance your multi-speciality. As we just discussed, hyper-speciality. So if you understand what your passion is and you decide that you want to specialize in a broad area or maybe even super specialize, you have identified that correctly. So then you also need to do other degrees that could help you. For example, a degree in engineering or a degree in fashion technology, a degree in medicine would all contribute, or a degree in finance would contribute towards your law degree, so that you can really contribute intellectually to that super specialization in the days to come in your practice. That's one thing. And second thing, all lawyers need to be in the game regarding the use of AI, especially generative AI, regarding all aspects. It's not just to aid you in your everyday legal tasks, but also in all aspects of your practice, be it the administrative aspects and also scheduling and docketing. So that you need to be in the game. Third thing would be to build a network, a good network of IP professionals, not just in India, but also abroad, a global network, and also cultivate a deep understanding of global IP laws, so that you are ready to address any of your clients' queries in the future, be it regarding the Indian laws or be it regarding the international filings and the international laws. Also, you can cultivate good mentors and build a good network of mentors who can advise you from time to time when you really need their advice on particular areas of law. So that is up to you and your comfort and whom exactly you aspire to be like and whom you have that comfort zone with. So you can build that network of mentors. I think once all this is in place, a person could very well reach the pinnacle of IP practice.
Wow. Thanks a lot for sharing these insights, man. These were really invaluable. Thanks a lot for coming on the podcast as well.
Thank you. Thank you, Avinash.
That wraps up our insightful conversation with Lakshmidevi Somanath. It's not every day that you get to question a former judge. So for me, it has been an honor. We hope you also found today's episode as enlightening and inspiring as I did. Stay tuned for more engaging discussion with leading legal minds on LexDiscuss Cafe. Until the next time, stay caffeinated, stay curious. This is your host Avinash Tripathi signing off. See you in the next episode.